Thank
Good
you,
afternoon,
Yili.
everyone.
Yes.
Thank you for having me here today.
Thank you very much.
I think most of you will be familiar with arbitration as an alternative dispute resolution mechanism.
Yep.
But I understand that construction education is not available in Vietnam.
Yes.
So I will provide an overview of the education process in Malaysia.
Right.
So construction education in Malaysia is governed by the Construction Industry Payment and Education Act 2012. We call it SIPA 2012. And the primary objective of the Act is explained by the Federal Court case of Artego, and that is to facilitate regular and timely payment and to alleviate cash flow issue in the construction industry. And SIPA is a form of rough justice. It's really fast and furious. And the core philosophy underlying SIPA is pay now, regulator.
Yep. Can you explain a little bit on that?
So SIPA is temporary, and adjudication decision is temporary in nature. It is only provisional, and it is a summary process. The whole process is meant completed within 90 days and 90 working days. So purpose is to ensure that contractors and subcontractors in the construction industry get paid as soon as possible, and even if they are prejudiced, can ventilate the issues at before the arbitrators or before the court. So an adjudication process starts with the service of a payment claim by an unpaid party on the non-paying party. The word payment is defined in Section 4 of SIPA to mean a payment for work done or services rendered under the express terms of a construction contract. So this excludes claim for LED or loss of profits because these are damages arising from a breach of contract and not payment for work done or services rendered under a construction contract. And a payment claim is basically a document setting out the amount claimed by the unpaid party and the due date for each payment. And it should also identify the causes of action relied upon by the unpaid party and the description of the work or services rendered. After receiving payment claim, a non-paying party has 10 working days to respond to the payment claim by serving a payment response. But what I would like to highlight here is that it is not mandatory for a non-paying party to serve a payment response. And if he doesn't do it, the effect is that he's deemed to have disputed the entire payment claim. In such a situation, a dispute is said to have crystallized on the 10th working day.
Okay. So let's say they say the quality is not good, therefore they don't pay, and there is a dispute crystallized.
If you serve payment claim on me and I do not do anything, I do not answer your payment claim, then a dispute is to be crystallized.
Okay.
So after dispute is crystallized, the next step would be to refer the dispute to adjudication. And that is done by serving a notice of adjudication on the Education Authority in Malaysia. This Asian International Arbitration Center, we call it AIAC. Not mentioned, it's not stated in the text. And Section 8 of SIPA provides that a notice of adjudication must contain the nature and description of dispute and the remedy sought by the claimant. But what is interesting here is that Section 7, subsection 1 of SIPA provides that both an unpaid party and a non-paying party can refer a dispute to adjudication. So that question is, how can a non-paying party refer a dispute to adjudication if he's not seeking any remedies under SIPA? So in this case of TWCE, we act for the unpaid party. And what happened in this case was the unpaid party served a payment claim on the non-paying party. The non-paying party then served a payment response and counterclaim for LED. The payment response was served on a Friday evening. The non-paying party then proceeded to serve notice of adjudication on the following Monday at 8:15 a.m. in the morning. And the unpaid party then served its own notice of adjudication on the same day in the afternoon at 2:30 p.m. And what the AIAC did in this case was they first registered the unpaid party's notice of adjudication. But after registering the unpaid party's notice of adjudication, the non-paying party wrote to the AIAC and challenged that registration. The basis was that it was the non-paying party who served the notice of adjudication first. They should be named as the claimant. So the AIAC then retracted its first registration and re-registered the non-paying party's notice of adjudication. And we have filed a judicial review application against the decision of the AIAC in registering the non-paying party's notice of adjudication. And one of the grounds that we have raised is that the conduct of AIAC in this case is inconsistent with the conduct of the AIAC in the case of tracks engineering. So what happened in this case, between the parties were the same, but the AIAC, instead of registering the unpaid party's notice of adjudication first, the AIAC registered the non-paying party's notice of adjudication. It was the unpaid party who challenged the AAC's decision. The registration by the AAC was reversed.
Yeah.
So in our case, the AAC registered the unpaid party's notice of education.
Yeah.
In this case, the AAC registered the non-paying party's notice of education. So the unpaid party challenged AAC's decision and claimed that they should be named as the claimant because it was the unpaid party who served a payment claim.
Okay.
So the AAC wrote to the non-paying party and requested the non-paying party to furnish a copy of its payment claim.
Yep.
And the non-paying party couldn't do it because it didn't have a payment claim. So the AAC then retracted its first decision as well and registered unpaid parties' notice of adjudication.
So in the previous case, should be first come first served. In this case,
Correct.
whoever gets unpaid should be the claimant.
Correct.
Yeah.
So that's basis of adjudication. One of the bases that that we are seeking. Sorry, one of the bases that we are relying on in our judicial review application. There's no finding by the High Court in any of these two cases yet.
Okay.
But I thought these cases will show the mischief of Section 7, subsection 1, and how it can be abused by a non-paying party.
Yeah.
Because the fact is that if a non-paying party is named as the claimant, and I will explain later, the non-paying party as the claimant will get the first and final say in the education process.
Right.
And Section 17 of SIPA also provides a right to the claimant to withdraw the education proceedings at any time.
Yeah.
So if the non-paying party became the claimant, then the non-paying party can withdraw the education proceedings anytime.
I can see that in Malaysia, they have a very good or advantage provision for contractors, the SIPA. Yes. Whereas in Vietnam, there is none of that yet. But but that's something we should learn from. And that's the SIPA is compulsory. It does not subject to any agreement to use the SIPA. No, right?
It is mandatory, but it only applies to construction contracts.
Of course. Yeah. Yes. Yeah. Thank you. So
hopefully the High Court in this case will be able to render some guidance on this issue in coming months. Yeah. So after a notice of adjudication is registered, either the director of the AAC or parties will nominate an adjudicator. And after the adjudicator accepts its appointment, claimant will have 10 working days to serve an adjudication claim. So an adjudication claim is basically a more comprehensive payment claim,
right?
But it has to be supported with all the relevant documents and the legal authorities.
And how long does that whole process takes?
A claimant only has 10 working days from the acceptance of appointment by the adjudicator.
Yeah. So let's say my response for not paying is that your quality is not good, and I have to hire a third party to correct your work. Although I haven't hired anyone yet, but I can take a picture, say that the quality here is not good. Is that an excuse for not paying?
No, because and that doesn't fall under SIPA because if I have to hire a third party to rectify your work, that does not fall under definition of payment under SIPA. So you cannot claim for that under SIPA.
That's a separate issue, right? That the quality, bad quality is a separate issue. You can sue at court, bad quality.
Correct. You can go to arbitration,
but you still have to pay you. Right?
Correct.
Yeah. Thank you.
So after receiving an adjudication claim, a respondent has 10 working days to serve an adjudication response. And one of the issues that have arisen in the past is what happens if there's no payment response by a respondent. And the reason why this issue arose is because Section 27 of the Act provides that an adjudicator's jurisdiction is defined by the payment claim and the payment response. So before the federal court decision in Martego, there were a host of cases which held that if there's no payment response, then a respondent is not entitled to put forward any positive defenses in the counterclaim. In the adjudication response. Right. It means that respondent can only answer an education claim but cannot raise any counterclaims or set off in the education response. So after the federal court decision, the court held that an educator has to consider all defenses raised by a respondent in the adjudication response.
They have to raise it in 6 days, otherwise it's barred.
You will have to raise it at this stage, in the adjudication response stage. Right. Yeah. So you have 10 working days to respond to the adjudication.
Right. But if I have a problem like or if you have a problem like I don't pay you, how much time you have before you can let's say if that is 3 months after I was paid, then maybe the adjudicator say that sorry, it's barred. There's no time limit to
I believe it would be 6 years.
6 years?
Yeah.
Okay. Yeah. So, if you have at most, you have 3 years.
For a contractual.
Yeah, non-payment. Or even the arbitration, you only have 2 years.
I see.
Yeah.
Sorry. So,
yes, that explains why the construction in Malaysia is so progressive more than in Vietnam. Because they're protective for the contractors.
Yes, very.
Yeah.
So after this federal court decision in Martego, it is arguable that this decision has rendered the service of a payment response redundant because a respondent is not required to serve a payment response anymore and doesn't really affect respondent.
Right.
So it is quite normal nowadays for a respondent to not serve a payment response, and they do it for a technical reason. And the reason is that no matter how bulky or how comprehensive your adjudication response is, the claimant only has 5 working days to respond to your adjudication response. Yeah, only 5 working days. So another issue that has arisen very frequently in the past is whether there's a right by the respondent to file a rejoinder if the claimant raises any new issues in the adjudication reply.
Okay.
The position is still very unsettled in Malaysia.
Yep.
But in this case of MRC builders, the court has taken a very strict approach and said there's no right to file a rejoinder for the following reasons. First, because SIPA has prescribed a very strict timeline for an adjudicator to deliver an education decision. An adjudicator only has 45 working days from the receipt of an adjudication reply to deliver the decision. And the second reason is that the purpose of SIPA is to ensure that contractors and subcontractors will get it as soon as possible. And the third reason is that SIPA is only provisional in nature. So even if a respondent is prejudiced by the fact that he's not entitled to file a rejoinder, the decision is only of temporary finality, and he can ventilate issues before the court or the arbitrators.
Yes.
But in another case, in this case of Sang Yong, the judge has held that the adjudicator must give the respondent a chance to comment on any new issues raised by the claimant in the adjudication reply. Even though the adjudicator has a very strict timeline to comply with, he cannot sacrifice the law of natural justice. But this position is the issue is still very unsettled in Malaysia. Hopefully there's a decision by the
natural justice for this case. Because SIPA is only for one purpose of no payment. There's the appropriate forum for discuss or anything else elsewhere.
Correct. So the last step in an adjudication process is the delivery of an adjudication decision by the adjudicator.
Right.
And as I've said earlier, an adjudicator only has 45 working days to deliver the decision. If he fails to do so, then the adjudication decision will be rendered void. So the whole process has
to have to go very fast.
Correct. And an adjudication decision is binding and enforceable in the interim. But just like an arbitral award, it is also subject to be set aside or stayed in high court.
Yes. It's final or just binding?
It's binding in the interim.
Okay.
But you can force it. Correct.
It's not final.
It is not final in that sense.
You can bring the dispute to the arbitration, bring the dispute to court.
Yes, and they can proceed in parallel.
Right.
So SIPA has been enforced for approximately 10 years now. And there are ongoing discussions as to whether it is time to reform SIPA. And the primary reason for that is that SIPA has now become very lengthy and costly.
Because 45 days is not lengthy.
Yes, but then half of the education decisions go up to the High Court. Parties apply to set aside or to stay an education decision. And the process does not end there because after High Court, the litigant will appeal to Court of Appeal. So, but I think that itself is not a defect in the system because judges in Malaysia are very pro SIPA. They ready to give effect to the purpose of SIPA. So on
the half that go to the judge, you can count on one hand how many times was reversed, right?
Correct. It is extremely difficult to set aside or even to stay SIPA. But I do understand why litigants are not prepared to accept an education decision. Because, like, for example, in one case that we have found, the sum claim by the unpaid party was 116 million ringgit. And to leave that 116 million ringgit in the hands of an educator who may or may not be legally trained, I think that the risk is too high for both parties. So if Parliament were to consider forming SIPA, maybe one of the areas to look into is whether SIPA should be confined to cases where the claim sum is below certain limit. So that's all for me today.
Thank you very much. That's wonderful. I think my question is, apart from Malaysia, is there any other country that has something similar to SIPA?
SIPA actually originates from the UK. So the UK, Australia, New Zealand, Singapore, they have similar system. But SIPA is peculiar to Malaysia in the sense that the provisions are not implemented with any other provisions, statutory provisions in the other countries. So it is quite special in that sense.
That's something really new and something for me to learn. Actually, in Vietnam, don't have that. We still arguing whether we should have DAB. DAB is something similar to SIPA. And somebody say yes, somebody say no, even if that is an agreement in the contract. So that also explain maybe why the construction in Vietnam is not as fast like in Malaysia. But the thing is that any system can be abused. And as you said, I mean, the system of SIPA You can claim like $100 million US, and the other party, they can't pay, don't have money to pay. Then you get the decision, and then you sue for insolvency for that poor guy.